My name is Michael Drake. I'm the Assistant State Engineer over the Adjudication section. And so we are the ones that are doing these adjudications that have been mentioned already. So let's get into it. What is a general adjudication? It is at its most basic sense, it's a court action in a district court in the state of Utah. This is a special type of court case. This is not like a criminal case. There's no grand juries, there's no perp walks, there's no rogue district attorneys. This is a court case in which the state engineer participates to evaluate water rights in a geographical area. So the state engineer has a really important role in this, and we'll go into exactly what that role is. Ultimately, and Gary touched on this a little bit, the judicial branch ultimately has the authority to forfeit water rights, which is part of an adjudication. The state engineer makes recommendations, but this is for the judiciary to do. The judicial branch also has the authority to determine rights, finally and conclusively. And so that's why this is a big court case. All right, so an adjudication, one of the most important aspects of this and what makes it a general adjudication is that it binds all water users, joins and binds all water users in a geographical area. And this is what we do. That's the primary purpose here, and we'll dive into more of what that means in the coming slides. The entire thing is governed by Title 73, Chapter 4. And that lays out the entire process. It's statutorily defined, so we follow that as we move through that. Referencing the map that you can see there, you can see that every hydrologic boundary or basin in the state of Utah is or has been under a general adjudication order. The earliest ones were done back in the 1920s with the Weber and the Sevier, the Weber, Ogden, and Sevier. And we continue working in the adjudication today. All right, so let's get into the why. Why do we conduct general adjudications? At the heart of it is this idea of bringing all claims onto the permanent record. And pre-statutory water rights is a critical part of joining and binding all water users. So let's define what that means. You probably are aware of your basic Utah history, right? We all learned this in 4th grade, I guess, if you were living in Utah at the time. The pioneers came into the valley in 1847 and immediately started diverting water. And the development of the basic water infrastructure occurred in that period following 1847. Statehood followed in 1896, and you do the math on that. It's about 50 years of time between the pioneers and statehood, and that's a lot of time for a lot of water development to happen. If you work for a water entity, that's probably when the basic or the fundamental parts of your water system were put in place. Furthermore, the first state water laws didn't become effective until 1903 for surface water and 1935 for underground water. And kind of defining these two types of pre-statutory water right is this premise that's laid out in Article 17 of the Constitution, of the Utah State Constitution. And it says that all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. Okay, so there's this idea that there was a lot of work that was done prior to statehood and prior to implementation of the first water laws. And so those water rights are recognized and confirmed, but the key lacking piece of information here is the quantification, the precise knowledge and details of what those water rights are. In the adjudication, we dive into those details. By joining and binding all water users, we require everyone to participate and bring those water rights onto the state records so that we know about them so that we can more effectively manage the state's water resources. Another aspect of joining and binding all water users, particularly for the western states and the state of Utah, is federal reserve rights. And reserve rights is kind of a special topic that we could literally spend hours talking about. I'll give you a real quick summary on that. It was defined by what's called the Winters Doctrine, which is derived from a U.S. Supreme Court decision in 1908. And the gist of that decision is that when the federal government reserves land from the public domain for a specific purpose, they also reserve sufficient water for the purpose of that reservation. The topic at hand in the Winters Doctrine was Native American reservations. And so the premise is when they reserve land for those Native American reservations, they reserve sufficient water for those purposes. This has since been expanded into a lot of different areas, a lot of different federal reservations, including Forest Service lands, national parks, national monuments, and military bases. We'll talk a little bit more about this at the very end, but suffice it to say, it's there. Now, to get those water rights quantified, we need to run that through an adjudication. Adjudication is the tool that joins and binds all water users. However, you normally, oh, there's my voice. You normally, oh man. I thought it would do better. You normally don't get to sue the federal government, but the McCarran Amendment makes it so that you can the U.S. government waives their sovereign immunity so that you can bring them into a state-based adjudication. Other benefits to adjudicate. Go ahead. Yes.
I'm sure there's a lot of precedents and case law that goes into this question, but how did they determine how much water they needed?
Yeah.
For these parcels?
And that gets extremely deep into reserve right. I'll give you a short answer. There's a lot of case law that determines how that's done. There's this concept of practicably, and it's like, why did they choose that word? Practicably irrigable acreage is, at least for the Indian reservations that they use. And so of the land that they have, how much could be practicably irrigated? And that's the amount of water that they would, that's been reserved in their benefit. Now, that's a basis. What normally happens is there's a lot of negotiation that is done between the three sovereigns that are involved in this: the United States, the Indian tribe, and the state of Utah, and that can be negotiated. And so it's a starting point, and then we work from there to arrive at a number. Oh, sorry. The question was how do we determine how much water is due to a reserved right, in particularly maybe an Indian tribe reservation. And so practicably, it's so hard to say, practicably irrigable acreage. Okay, some additional benefits there. We do look at non-use in the adjudication. So if a water right hasn't been used, either wholly or partially, then we may recommend it to be forfeited. And the final goal of an adjudication is to obtain a final comprehensive decree. And that's what we're all working for. Okay, this is the adjudication process. And I'm just going to keep sipping here. It seems to help my voice. All right, so we'll generally review this, and then we'll dive into the details. You can see that generally there's three different colors here, and that denotes the three different phases of the adjudication process. The first phase starts with a petition and ends with what's called the notice to file claims. At this point, all water users must submit what's called a water user claim. Failure to respond at this time can have some pretty lasting effects. You might be barred from filing a claim of any type in the future, including diligence claims. So it's pretty critical that you participate during this 90-day period. That's the first phase. The second phase is the list of unclaimed rights phase, and so we compare the claims we've received and with the records we have, and we compose a list of rights that are not claimed, and we file that with the court and ask them to abandon it. And then the third phase is the claim investigation phase, and results in what's called the proposed determination. And I'm going to dive into all of these in detail, so don't worry that I'm going really quick on this part. Let me just make sure I hit everything I wanted to hit here. Yep, I got it. All right, so moving on. Phase one. The first step in this is the petition. This is typically not relevant today. If you recall that map on the first slide, all of the areas in the state of Utah have been commenced. There's the petitions have already been made, and we have adjudications underway. So moving on to step two, what we do is we break down those large areas that you saw. You know, those adjudications are very, very, very big areas, and so we break those down into smaller areas, and then we will start those an individual subdivision one at a time, and we'll start that with what's called the notice of commencement. That gets published in the local paper for 2 weeks. Right about the same time, we also send out a summons. This is the scary part. This gets a lot of phone calls and a lot of concerned people. So we publish the summons in the local paper for 5 weeks, and we send out a mass mailer to all known water right holders and all property owners within the geographical area. So it's huge. That's, you know, we're looking at thousands of pieces of mail that go out when we commence an area. Most of those people don't have water rights. You know, just because you have property doesn't mean you have a water right, but we do this to make sure that the adjudication is as comprehensive as possible, so that every potential claimant has been identified and given an opportunity to participate. We hold a public meeting, and we discuss what's going to happen, and a few weeks after the public meeting, we send the notice to file claims, and that starts the 90-day period in which all water users have to submit a water user claim. And again, failure to participate during this time frame has very lasting effects. You may be barred from filing a claim in the future.
In that process, the people everybody who has claim on a right, whether it's on the piece of paper or not, falls into this. They have to file a water user claim.
Correct, yeah. So everyone does that. One of the most common problems we find as we adjudicate is that title has not been kept up. And so it's really important that everyone, that's one of the reasons we send it to all property owners as well, is to broaden that group of people that are notified, and they will then participate in the adjudication. So every water user. Now, there's a couple, there's different types of rights that we'll get into in just a minute. I'll talk about what rights are subject to the adjudication. There's a slide that talks about that, but let's stay general for now. Every water user needs to file a water user claim. Okay, any other questions right now? We're going to keep going a little bit deeper on this. Okay, this is a sample water user claim. The form looks like a lot of the other types of forms that we use in the state of Utah in the Division of Water Rights. And you know, what more would you put on it? It's quantity of water, place of use, nature of use, point of diversion. Those are the types of things that you'll see on a water user claim. we understand during if you're in an active adjudication area, this can be very challenging still to file a water user claim. So we have a large number of staff members that can help water users with this. There's also online resources that can help with filing a water user claim. When we send out the notice to file claims at the beginning of that 90-day period, we also include a water user claim in that mailer. And if you are a known water right holder, then that water user claim will be partially completed. It will look like the database. And you may only need to sign that water user claim and return it to us. If you are not a water right holder of record, then you'll receive a blank water user claim in the mail, and you would need to complete that water user claim and send it to us. Okay, so water user claims are only required for perfected water rights. And what does a perfected water right mean? That is a certificated water right, a decreed water right, a diligence claim, or an underground water claim. Claims are not required, although it's okay if you submit on a share statement. And so if you have a water right that's based on shares in an irrigation company, you have at some point probably come in and filed or received a share statement and then filed a change application on that share statement evidencing your shares. It's not strictly required to file a water user claim on that. In the case of an irrigation company, the irrigation company is the entity that's responsible to file the water user claim, although it's okay if you do. We'll take them, we'll file them, and at the very least your water right will be claimed, your portion of that that's evidenced by those shares. Exchanges do not require a water user claim, but again, it's okay if people do. There's no problem with that. The reason for that is exchanges are typically based on an underlying water right. We have a question.
When we're talking about adjudication, are we talking just surface water, or are we talking underground as well?
Correct. Yeah, so the question is, when we're talking about adjudication, is this surface water or is this underground water as well? The early adjudications were surface water only. The adjudications we do now are fully comprehensive. They are underground and surface water all together. Another question.
So these adjudications take multiple years, I'm
Oh, yeah.
guessing. And I've never known of someone receiving this documentation. What happens if you're not in on that initial burst and you come in a month or 5 years later? Do you then, what happens in that process if you come in not at the beginning? Do you miss your opportunity to file a water user's claim? Or knowledge of that you need to?
Yeah, great question. I mean, I think you are getting to a pretty specific sort of question. If you're coming into the picture, then presumably someone was there before you that you were buying the property from or something like that, that would have had a requirement to file a water user claim at that time. And now as the purchaser, you inherit whatever they did. And so it's on you as the purchaser to do your due diligence and make sure that they have claimed the water right as they should have when the notice to file claims came through. So, but I do wonder if you're conflating a little bit this with appropriation policy of the state engineer. And don't confuse the two. I know we've talked about appropriation policy. Nothing we do in the adjudication prevents the state engineer from implementing change application policy or appropriation policy. And so if an area is still open, it might still be open after an adjudication. I don't know. Is that where you were getting at? But we're talking about perfected water rights. We're not getting into applications to appropriate or anything like that. Okay. All right. So moving on here, phase 2. Once all the water user claims have been received, we prepare what's called the list of unclaimed rights. So we do a comparison of all the claims we received with the records that we have of all known water rights. And if there's a water right on our records for which we did not receive a claim, we put it on this list. And we file the list with the district court and proceed through this second phase of the adjudication process. There's another public meeting, and ultimately, if you don't, there's a 90-day period to object to that list of unclaimed rights. So if, for example, you didn't submit a claim earlier on and you find a water right that is yours that's been listed on the list of unclaimed rights, you can file an objection and potentially have that removed from the list of unclaimed rights. There is a final summons at this time period where we search our records and try and identify any other potential claimants, and then we ask the court to close the area to any subsequent claims. And I guess maybe the last detail I have here is what we ultimately ask the court to do is to abandon all of those rights that are on the list of unclaimed rights. And so that gets all of those rights off to the side so we can now focus on the rights that have been claimed and presumably are in use. Okay? All right, phase 3. Oh, question. Go ahead.
It's not a very relevant question. I just wonder, what is that? How many unclaimed rights are there typically in an adjudication?
All right, so the question is, how many unclaimed rights are there in an adjudication? Very highly dependent on the area. In the recent past, we've been working in the Salt Lake, Utah, and Utah counties and up into Wasatch as well. And we'll typically see anywhere between scores, 20s, 30s of water rights up to hundreds of water rights that are being abandoned. Most commonly, these are small, what we would characterize as small domestic water rights that were in place when these areas were more rural. And now these cities have stepped in and are replacing those little wells that used to be in place. So, all right, phase 3. Let me change my paper here. All right, this is the part where we probably have the most work to do in the state engineer's office. So we evaluate each and every water user claim in that geographical area, and we go out, we do a field review, and we're looking to verify the point of diversion, the place of use, the beneficial uses, and we ultimately come around and prepare what's called a state engineer's recommendation. We abbreviate that as SER, and we also prepare a memo that is placed on the file. And the memo and the SER are both mailed out to the water user and the claimant. And what that SER is a preliminary indication of the state engineer's intentions in the proposed determination. And let's turn to that. We'll see an example and talk a little bit more about this. These are just a couple examples of 2 SERs. You can see it looks like, again, any other form that we might have in the state engineer's office has the typical type of information that you would expect. If this differs from what you expected, we welcome additional information. We're happy to reconsider these in that period between the notice to file claims and when we publish the proposed determination. And so if we get something wrong, if we make an error, if we overlook something, we're happy to talk with water users about this. Let's talk about some of the recommendations we may make. If we go out and we find everything in place, then we're probably just going to regurgitate what has been claimed, and there's probably not going to be any surprises on that SER, that state engineer's recommendation. However, if we go out and we find that the water right isn't in use, we can't, maybe hearkening back to the last presentation, there's a Walmart there now, then we may recommend that water right to be disallowed. If a water right is found not to be valid, then we may recommend the water right to be disallowed as well. And so we try to be very transparent throughout this entire phase and make sure that the water user knows what we're intending to do, and that there's plenty of opportunity to provide as much information as possible. We frequently amend SERs throughout this entire process and make them match all the information that we're able to acquire during that evaluation period. Okay, so we'll bounce back here to the phase 3 because I don't think we were quite done. Once we have compiled all of the, or once we have done a field review, we've investigated each and every claim, we file a proposed determination with the court. A proposed determination is simply a book that contains all of the various recommendations compiled into that single resource, and then that's filed with the court. Following the pattern that we've seen previously, there is a 90-day period to object if you don't like what has been recommended, and there is a final public meeting as well. So let's talk about what the proposed determination is. The proposed determination is the state engineer's recommendation to the court as to the status and the nature of all of the water rights within that geographical boundary. We also prepare another document at this time. It's called the Hydrographic Survey Map, and we'll take a real quick look at that. And that's simply a map that shows points of diversion and places of use for the various water rights in that geographical boundary. Okay, we talked about objections. So you can object to this proposed determination if that doesn't match what you expected. And so following the publication of the proposed determination and that 90-day period, we then enter into a phase of objection resolution. Once we've resolved all of those objections, we can then petition the court to issue a decree. And that decree finally is the final document or the final action that ends the adjudication process. And that's ultimately what we're looking for in these adjudications, is to get through this process and get to the judicial decree at the very end. Question?
What happens if in that general hydrologic area you have many more rights than what the hydrology can produce? Like, so there's more water demand than there is supply. What does the state do in a case like that?
Well, the state has other ways of managing it, but that is, oh, sorry. All right, so what happens if at the end of the adjudication we find that there are more water rights than there is water available to satisfy those water rights? Is that correct? Okay. So that determination is not part of the adjudication process. We don't consider that in the adjudication process, but this is the tool that permits us to implement that type of management if needed in an area. And so we have other tools that we can use, groundwater management plans, for example, or simply priority distribution. So we would just distribute to who has the earliest priority first, and if the water runs out for the junior appropriators, then they wouldn't get water. But I hope you can see that in a lot of areas we don't have the information to be able to do that, at least prior to the adjudication. So the adjudication is the tool that permits us to do this. This is why the Sevier, the Weber, the Ogden were done early on, is we needed to have those tools to be able to manage those rivers. Any other questions there? All right, this is a typical page from a proposed determination. Again, no surprises here. It contains the same sort of information that you would expect. It's simply a description of the individual water right, and includes the common descriptors that you would expect: point of diversion, place of use, nature of use, quantity of water, all those types of things. So we file this with the district court and then solicit those objections and then work through those objections. This is the hydrographic survey. This is an example of a hydrographic survey map, and the scale is not great. You can't see very much here. I get it. if the resolution was a little bit better, you could see that there are some irrigated areas that are delineated there, as well as some points of diversion. The Hydrographic Survey Map is available in our office. We also make it available online, so you can consult that and review what that is. The Hydrographic Survey Map is a snapshot in time. It represents what we saw and what we investigated and was present at the time of the proposed determination. This isn't a map that we keep updated through time. The continuation of state engineer records is what's going to keep things up to speed and present. But this is a one-time snapshot in time of what we found in the adjudication process. So last couple little details on reserved rights. Won't spend a lot of time on this. And I discovered that this map is slightly out of date because this map shows the areas where we have joined the federal government. There is one area that we added recently as part of the Navajo Nation adjudication, and so that southeast corner of the state of Utah should have a little an area of green that represents the Navajo Nation. Types of reserved rights. We talked a little bit about this earlier. National parks and monuments, military reservations, Forest Service lands, Bureau of Land Management, and Indian reservations all potentially have reserved rights. And to participate in these adjudications and in the adjudication process, we have to summons the federal government, enact the McCarran Amendment, that was when I was choking, and have the U.S. government waive their sovereign immunity so that they can participate in our adjudications. The reason the whole state is not green is we typically try and keep them out of our business until we need to, until the rights that we presume are there are so significant that we need to bring them in so that we have a clear picture of what's going on in the area. And that's what happened with the Navajo Nation is we had a signed settlement agreement between the three sovereigns, and we needed to implement that into state water law, and so an adjudication is underway right now down in the Navajo Nation. Negotiation is Utah's preferred strategy. I had a great question about that earlier, about how you define them. How Utah chooses to define them is through negotiation. We talk with these tribes and with the federal agencies to try and define what these water rights are. And that's the end of the adjudication presentation. If there's any questions, I think we have a little bit of time for questions.
What is your schedule? Do you guys have a plan for how you go through the state? Are there certain rivers that, this is for areas that this is the area we're going next?
Yeah. Great question. So the question was, what's our plan? Do we have areas that we're adjudicating? And we do. Adjudication is a very, very long-term project. It's been going on since the early days, just after statehood, the 20s and 30s. Various changes have been made to statute that have in the recent past that are accelerating the work. Where we are working right now is in what's called the Utah Lake Jordan River adjudication. That includes Salt Lake County, Utah County, Wasatch County. It follows the Provo River, basically. That's our most active area that we're working in right now. In the near future, we're looking to finish out the Utah Lake Jordan River, which would take us down to the south part of Utah County, the Payson, Santaquin area. We're also working in the Virgin River area, and these outside, these areas away from Salt Lake are typically managed by the region engineers, and so the Virgin River adjudication is one area that we're working in and will continue to work in the near future. Also, we're working in the southeastern Colorado River adjudication. Most recently, we published proposed determinations in Moab, the Moab area, and we'll continue to work in that area, but we're also working in the Navajo adjudication, which is part of the southeastern Colorado. We have a little bit of work happening in the Bear. The Bear is very close to being finished, very close from a adjudication perspective, which still means probably years, but a lot of work has been done there, and the region office continues to work in that area. And so being such a long-term project, that's about the degree that we have. And literally that, what I just described there is probably 10 to 20 years worth of work. And so we know where we're going in the short term, and then we'll follow the priorities that come as we identify them. The priority right now is get the populated areas done, and so that's where we're working. Any other questions? Okay.